Morning, everyone. Please be seated. We are here this morning for the submission of 4 cases. The first case of State versus Duffield is hereby submitted without oral argument. The case of State of John Johnston is also submitted without oral argument. Our first oral argument today is the case of Hampe versus Charles Gabus Motors, and it looks like the parties are ready to proceed. Mr. Tice.
Thank you, Your Honor. May it please the court and counsel. This case stems from a civil action under the private sector drug testing statute. The purpose of the statute is to protect an employer's right to ensure a drug-free workplace while also ensuring the accuracy of drug tests used for adverse employment actions. To be clear, the purpose is not to provide carte blanche testing for employers, nor is it to provide a gotcha for employees who might be rightfully terminated. When we have challenges, the claimed violations are reviewed for substantial compliance only, and also to determine whether the claimant has been truly aggrieved. Technical violations are not good enough. Here, Scott Hampe's employment with Charles Gabus Motors was terminated when he walked out of random drug testing against the warnings and directives of both his employer and the drug tester. While initially apologetic for his actions, Mr. Hampe has since done an about-face and brought suit claiming that he was targeted. The targeting claim is premised upon a far-ranging theory of a conspiracy to manipulate testing to put his name on a randomly selected alternates list where he only may be called if others are unavailable, and then further only to reject his proffered specimens so that he would walk out of testing against the directives that he received. It's a irrational theory of targeting that has no support in the evidence. So the district court, we believe, was correct to throw out all claims. The Court of Appeals, of course, has since revived 3 of the statutory drug testing claims. These are the challenges to the selection process, the training of a supervisor, and uniform disciplinary policies. Charles Gabus Motors believes that it was substantially compliant with the statute for testing on December 5th, 2019, and that Mr. Hampe would be unable to show he was aggrieved by any claim violations. So if we look at the first violation that we've presented to this court on further review, it's the selection process. The statute at subsection 8A sets forth the pools that are subject to random testing. The Court of Appeals found a genuine issue of material fact under this section, believing that Charles Gabus Motors had exempted specific employees from testing by not calling in to test employees who were not at work at the time. We believe there was no exemption here, but instead everybody was included. And in fact, I don't think there's any dispute in the record that all employees at Charles Gabus Motors were included for random selection testing. All randomly selected employees who were present were then called to test without any exception.
Wasn't the issue with respect to the selection, the fact that Gabus Ford did not exclude the people who were not scheduled to be at work at that on the day of the testing?
Yes, it is, Your Honor. So the statute, of course, we're talking about subsection 8A, says that employees who are not scheduled to be at work at the time of the testing is conducted, or employees who are excused from work prior to the time the testing is announced to employees are not to be tested. And so those would be, we believe, include those employees who aren't there at the time the testing is done. And I think it raises an interesting question that's different than what this court previously considered in the Dix case. You know, the Dix case was, as I read the decision, a case where the employees were within a warehouse. They appear to be largely, if not entirely, hourly employees that would have their schedules dictated by others where you could go and check to see what they were. And they don't appear to include employees who would travel. They would all be within the warehouse, whereas this is a different type of a workforce. The people that are included here for testing at Charles Gabus Motors are everybody at the company, from the newest hourly employee all the way up to the CEO.
That's what the challenge is. The challenge, that's fine that it's everybody, but the issue was that the statute defines the pool as everybody except those who were not scheduled. And you didn't have a process for excluding the people from the pool who were not expected to be at work that day.
So was not done before the list was provided to the third-party vendor for the random selection process. But that's what, in practice, is being done, I think, here when they show up for the testing. So those people are excluded.
The statute sort of literally requires that you create the pool first, excluding the people who aren't there. And what happened here is a pool was created, including people who might not be there, and then the people who weren't there were just taken off later. And you're saying that's substantial compliance? Is that the argument?
That is the argument, Your Honor, yes. And I think that we're trying to be practical in the application of a statute, a challenging statute, admittedly so, to apply to all different types of workforces. And so my point here is that this is a different type of a workforce than the one the court was considering in Dix, where if we do it the other way around, I just don't know that it's practical or, quite frankly, even helpful. The practical side of things, I think, is that when we look at this type of a workforce, which includes everybody, we're saying, well, before you even submit a list to the drug testing company, you should go and check and see what the schedules are of everybody in the pool, including the executives and the CEOs who may not have their schedules set by somebody else, who may not have their schedules laid out in writing anywhere.
In Dix, there were a few errors because people ended up not being there that were maybe supposed to be there, and we said that was okay. So in a way, this system works better, arguably.
Submission. It works better and perhaps is more appropriate for this type of an environment rather than an inclusive warehouse with people that have others assigning their schedules and they're not moving around.
Practicality or the difficulty change the fact of what the statute says, though? I mean, can we just say, oh, it's a difficult statute, and so we're going to find a workaround? Is that kind of what you're doing here?
The statute is difficult, and I've read it a number of times trying to figure out how really to apply this to the many varied workplaces we have. And I think there might actually be some wiggle room in the statute to acknowledge that this is the way to do it. It's not something I've seen in the prior cases. It's not something that was presented to this court in the Dix case either. So I don't see any problem with the prior cases that would say, hey, this is the sequence of things, but I'm not quite sure that the statute itself boxes all different types of employers into that.
As a factual matter, I had understood that there were some people maybe making deliveries that were on this list that weren't called back in to be tested. And in other situations, those people maybe had been called in to be tested. Am I right about that?
You are, Your Honor. So there were, I believe, 2 employees that were randomly selected for the December 5th testing that were parts delivery people that could have been, per the testimony, anywhere in the state or even beyond the state. So, of course, when the supervisor called the department director asking for that employee to attend, the director was obligated then to go search and find and see if they're there, and then responded to say, no, they're not. So I think the record is presumptive that they were somewhere out in or outside of the state. The other instance you're referring to, I think, is Mr. Hampe himself, who indicated that the prior month he had also been randomly selected for testing, and then he had been notified by his department manager, I think, while he was away to come in for testing, and he did. So the evidence there also shows that the director of the testing here, which was Kelsey Gabus McBride, was unaware of that at the time. So I think that's one of those perhaps exceptions that falls through the cracks, and we know that the statute allows for some measure of human error. In a prior and separate testing, different from the one we're here talking about, where the information was garbled somewhere in the process and never got back to the director of testing to say, well, hey, Mr. Hampe's not here. Does he have to test? That never happened. There's an affidavit I know in the record from Ms. McBride that says, I was unaware that he was off work that day.
That's the aggrieved part of this alleged statutory violation and what your argument is on that he wasn't aggrieved even if there was a violation of this pool requirement?
That's a tough part because we're dealing with a process that by statute requires random selection and to be done by way of computer. So the district court was presented with that question and found it's purely speculative to try to figure out if under different circumstances Mr. Hampe would or would not have been included on the eventual list and called in to test. The Court of Appeals came out and said, well, it's possible That's the word the Court of Appeals used. It's possible that he would have been included on a different list. The Court of Appeals doesn't explain how it came up with that possibility. I think everybody can probably see that with a random computer generator, we could put in all different types of lists. We might get the same result, we might not. But I think that's purely speculative, at least that we would agree with the district court.
Right. The pool in this case, if anything, was bigger than maybe what the statute should have allowed. So his chances for selection were actually smaller under the test as it was administered. Is that right?
I don't think there can be any argument over that. And, you know, another difference I see here between this and the Dix case is, in the Dix case, the employer there was included 100% of the operative workforce within its selection. I think it was roughly 90% on a primary list and 10% on an alternate list. Here, we have roughly the same employee pool size of about 170 employees. They were only looking to test 15. So they had a primary list of 15 and an alternate list of 8, so only 23 of them. So when they included anybody and everybody, I think it drastically reduced the likelihood that Mr. Hampe would actually be selected. That's the only part we know for certain.
Our precedent on aggrieved, I agree it's a good question, but I read like the Woods case, you know, we said the employee was aggrieved because even though Woods testified he might not have asked for a retest had he been informed of the cost of the test. He was aggrieved when he was prevented from making an informed decision, and there is no way to know what the outcome of the retest would have been. So that there, you know, we, so to speak, indulge speculation. It seems to me under our aggrieved precedent, the employer, in order to say the employee is not aggrieved, has to show that clearly the outcome wouldn't have been different, not that there's a question whether the outcome would have been different.
I guess one interesting facet to the statute is that it does put the burden on the employer to show compliance. I don't believe it does put the burden on the employer, and I struggle to figure out how it could, to show aggrievement. Of course, that part is on the challenging part of the employee, and so
A random selection, if it is violated, how would you ever show that it, I mean, how would the employee ever show that he was aggrieved if the employer did blatantly, or not blatantly with respect to the random and select person, but how would you ever show that someone was aggrieved if they failed to put together the correct pool?
think of it in two different ways, Your Honor. One, we look at the important objectives of the statute to determine substantial compliance, and those objectives are to make sure that we're not targeting or exempting specific employees. And so I think an employee who wants to challenge it, if they had some evidence that there was actually targeting or exempting going on here, that's how they would do it.
Purpose of it, but how would they show? So your position is basically you're not aggrieved unless you can actually show and have more than speculative proof of targeting.
Now, I think that the statute also, though, does allow under subsection 15A2 for injunctive action, which would not just be aggrieved employees, but also county attorneys or the Attorney General's office. If somebody thought that this process was truly illegal, but there's no showing of aggrievement, but they wanted to remedy it, I think there's an option to remedy there, which may not require aggrievement.
Before your time is up, I wanted to ask you about the lack of uniform policy issue, which was, as you mentioned, one of the other things the Court of Appeals reversed on. And, help me with that, because it sounds like the employee handbook states refusal to consent to testing may result in disciplinary action, including termination. That sounds like a uniform discretionary or a uniform, non-uniform policy. Help me out.
Uniformly applied to the entire employee workforce. I think that language you're talking about, actually, it seems fairly clear to me, was taken right from the statute, subsection 10, that lists off the disciplinary measures that could be taken. So it looks like that was put into the handbook itself. But when we look at the actual options of suspension, refusal to hire, no evidence of other actions available under the policy or procedures, it looks like the policies actually are saying, well, look, we can suspend when we have a presumptively positive test subject to confirmation. We have termination. A refusal to hire doesn't apply to current employees, and there's no evidence of any other types of actions that might be taken here, I think effectively the policy does become limited, even on its face. And then we know in practice, the evidence is clear and irrefutable. They always terminated. So we get to that aggrievement component again. You know, the only evidence here that the Court of Appeals identified for aggrievement under that challenge was these 2 affidavits from other employees that described their interactions with the testing agent, but not with the company's manager in charge of testing. So that information never got back to the company. They didn't apply the disciplinary policy in this case in that regard. I mean, it was applied because there was a refusal. And of course, that distinguishes Mr. Hampe, I think, from these alleged comparators as well.
Part of it maybe has to do with, does policy, uniform policy mean they have to act consistently, or does it mean they actually have to have a written policy that's uniform, right?
Technical, and technical is not good enough here. Thank you, Your Honor. I see that my time is up.
Dickey.
Madam Chief Justice, and may it please the court, my name is Gary Dickey from Dickey, Campbell, and Sahag Law Firm in Des Moines, Iowa, appearing on behalf of Scott Hampe, who asked this court to reverse the district court's ruling on the cross motions for summary judgment and affirm the Court of Appeals decision, which got 3 of the 5 issues correct. If there's any fault in the Court of Appeals decision, is that it didn't address the issue with respect to the alternates list, and it was incorrect in its analysis of whether or not Mr. Hampe was aggrieved by the discharge, the discarded sample. Justice Mansfield, I'll start with your question because I think it's important to understand the process, and I'm not sure my friend, Mr. Tice, made it clear what the actual process was. The statute requires that you create a pool of all the employees at the work site, you take out the individuals who are not scheduled to be there or anybody exempt by collective bargaining. They clearly did not do that. There's no dispute on that. What they did is they created a list that had people who weren't supposed to be there and then created an alternate list. They never took out the people who were not supposed to be there. Those people stayed on the list, and then when it came time, if they weren't there, they were just skipped. So the problem with that, so because of that, Mr. Hampe is aggrieved in 2 ways. Just as a factual, practical matter, that built in discretion into the testing policy, which our legislature expressly forbids. The whole purpose of the pool requirement is so there is no movement in the joints of the testing policy. And by allowing them to have the discretion to excuse people who are on an errand, who are not there, and then work their way all the way down to Mr. Hampe allows them to target him. Now, we think that there's circumstantial evidence that he was targeted, but we don't have to prove that in order to prove the statutory violation.
Circumstantial evidence in the record that shows this was manipulated in an effort to target him.
There's the establishment of an alternative list and failure to follow their past practices, which if there's an individual, mid-Iowa stays there all day until the individuals on the list come back. They did not do that. In past practice, when he wasn't supposed to be there for scheduled for work, they asked him to come in. There were individuals who weren't supposed to be scheduled for work. They didn't ask those individuals to come in. And then when you get to the disciplinary, there's evidence that they were not uniformly applying the disciplinary process. He was clearly, he was unclear about what the disciplinary sanctions were because he talked to the supervising officer, Kelsey McBride, Gabus McManus, and said, "Am I going to be terminated?" And she says, "Yes." And he thought about what his options were and walked away, which is not what the policy says. The policy says they have discretion. And it would be one thing if she said, in this situation, we're going to exercise our discretion and terminate you, but that is not what she said. Now, there's a second reason, Justice McDonald, why he's aggrieved, and this is anchored expressly in the text of subsection 8. So as we identified in our resistance to the application for further review, there are certain keys that unlock an employer's ability to even test. And Mr. Tice acknowledged that in his opening remarks when he says the statute doesn't give them carte blanche. So a couple of provisions are keys that unlock it. Subsection 8 is one of those, and it states employers may conduct drug or alcohol testing as provided in this section. And so the negative corollary is that if they don't follow it, if they don't follow that section, then they may not. And that section is the pool requirement that requires you to withdraw people who are not scheduled to work. So when we get to the Dick's opinion, and it talks about what an aggrieved employee is, Dick says that a person who loses their job based on a drug test that never should have been performed in the first place is aggrieved.
Just a moment ago, you said, when Mr. Hampe said, am I going to be terminated? And she said yes, and she didn't say, instead of the question, am I going to be terminated, we're going to exercise discretion, and yes. You're telling me that's completely different from each other?
Yeah, so if that's what I said, I think I've overstated. My point was there's a reason why there's a uniform policy for discipline. Again, it's to take all of the movements out of the joints in this framework. So if X occurs, then Y is the result. So what their policy says, if X occurs, then we don't know, you as the employee do not know what the result is. And so that's...
He said, am I going to get terminated? Yes.
It would be one, so by saying automatically you're going to be terminated, that's not following the policy because she was not exercising discretion at that point. It would be one thing if she said consistent with the policy, if you refuse to give a third sample, which by the way, there is no authority to demand a third sample, so that's a problem in and of itself. But if she had said, hey, read the handbook, consistent of that, we may impose a whole host of sanctions, including but not limiting to termination. But she made it sound like it was mandatory, which is inconsistent with what the policy said, which is the whole purpose of why we would want a policy. Indeed, in the McVeigh decision, which...
Persuasive of an argument if he decided to stay and give a test because she said it's going to happen. But if she came right out and said yes, and he walked away, doesn't that make a difference?
I don't think it does. The whole purpose of requiring a written policy is so that individuals like Mr. Hampe can open up the policy and see what it says so that they don't have to say, mother, may I, to the supervisor and allow them to exercise their discretion. And the Court of Appeals cited the McVeigh decision from this court in 2006. And that was the instance where the worker was never provided with a policy that included a disciplinary procedure.
Actual question. In your brief, there's discussion about how the person who did the testing didn't receive the adequate testing, or the supervisor, whoever it was, but later on she did. Does that, I thought the record showed that later on she did receive adequate training that would have covered all the bases. Is the argument that a person who doesn't get that upfront training can never become that supervisor type position?
Well, I mean, I think our argument is at the time of testing, she has to be qualified to have the training. And at the time of testing, she did not have the training.
The argument was you have to get 2 hours of training your first year. She got like 2 hours her second year or something like that, which sounds bizarre. So, that would mean that person could never, ever be a supervisor, right? By your interpretation.
Only issue was the amount of hours and whether she had the total amount of hours, then perhaps substantial compliance excuses that. But that's not what the issue is. The issue is you're required to have training on 3 specific subjects, one of which is record keeping, and she didn't have that. And so from a textual perspective, he is absolutely aggrieved. Again, this is the second key that unlocks the door.
Record is pretty skimpy on that issue. It looks like she had some standard training for this kind of thing, and maybe you can infer that the standard training would include all 3 subjects. At a minimum, it doesn't seem like your client proved the opposite, that she didn't have the required training.
The Appeals is absolutely correct. I mean, what you just described as a genuine issue of material fact, and the court can't decide that on summary judgment.
Unless you have the burden of proof, in which case you have to have some evidence that she was inadequately trained.
Mr. Tice explained under subsection 15, the burden of compliance is on the employer.
A question about, I'm going to call it the kind of but-for theory of being aggrieved, that the statute sets up this structure that drug testing can only be done in accord with the statute, and any violation of it means the testing shouldn't have been done, ergo he's aggrieved. I think that's kind of your second point, right?
So only with 2 subsections, is it a but-for aggrievement? So those are subsection 8, which says employers may conduct drug and alcohol testing as provided. So that's the key to unlock it. The other section is subsection 9, which says textually, in order to conduct drug or alcohol testing under this section, the supervisor has to be trained. So those are specific textual requirements in order to test anybody for this.
8 relate to.
How you draw your pools of individuals who are at the work site, not scheduled to work, or subject to exemption by collective.
Violations, the pool and the training.
Under Dix, because nobody should be tested if those are violated. Now, other provisions of subsection 730.5 are subject to potential, so what? We didn't follow it, but so what? You haven't been injured. That type of analysis. These under Dix are pretty clear. You do not even get to the day of testing if you.
Take the training example. So if your theory is that the supervisor here didn't undergo the required time of initial training in the first year, and there were some subject matters that weren't covered, anybody in the company, whether or not the defect in training led to any defect in the actual drug testing procedure, all of those results, everybody's aggrieved by the drug testing.
Only if there's an adverse employment action associated with it.
Right, fair enough. But anybody who was terminated, suspended, whatever, they're all aggrieved by the failure of initial training, even if there's no other defect in the testing procedure.
Dix, and they're not asking this court to overrule Dix. Under Dix, if an individual is subject to an adverse employment action based on a drug test that should not have been administered, that's aggrievement. And those two subsections make clear you do not get to administer a drug test unless you have met those conditions.
Difference between the drug test should not have happened to this specific person because the pool was not properly put together, and the pool was properly put together, and so this person was properly drawn from the pool, but the testing itself should not have happened, is what you're saying. Or I'm sorry, it should not have happened only because the supervisor wasn't properly trained. Is there a difference between those? It seems like, I think that the aggrievement with respect to the pool is if the employer put together the pool wrong, we don't know whether or not you would have been chosen in a correctly gathered pool. But with respect to the training, to Justice McDonald's question, we can tell whether or not the supervisor did something wrong with respect to their training. Does that make?
Again, if this court follows Dix, that an individual who should not have been tested gets tested and fired, then. But I think the second point maybe is sort of a kind of quasi injury in fact standing argument, and I don't know if that's where you're going, but if we look at the nexus between the education requirement and Mr. Hampe's injury, I think it's there, if that's what you're asking.
Right, that's my question. It's one thing if you're not, you should never have been tested because you shouldn't have been in the pool. It's a different question, or you shouldn't have been selected. It's a different question from whether or not this person who was supposed to have had training maybe missed one of the hours of training, but do you have to then point to a specific problem with the way she conducted it because she didn't have the training?
I don't think we do under my analysis, but I'm happy to go down that road if I'm wrong.
What you're advocating for is sort of a strict liability concept of aggrieved, that if there's any, sort of problem in the testing, regardless of whether it was consequential or not, then the employee has a cause of action. They're aggrieved. And what that language in Woods that I read suggests something different. That is, and I think Dick suggests something different. There can be no harm, no foul violations where they don't taint the whole thing. There has to be some possibility that the outcome would have been different if there had been compliance with the statute.
Woods is not dealing with a violation of subsection 8 or subsection 9. So, and that's why our argument's anchored in the text. So yeah, I don't think you can, again, Dick says if you shouldn't be testing them, then they're fired because of a test they refused, they should never have been given, then you're aggrieved. Now, with respect to the education requirement here, the second subject is the documentation and corroboration of employee alcohol and other drug abuse. I mean, that seemingly covers the testing procedures, which is problematic here because she dumped the sample twice.
So on that destroyed sample, the argument, I guess, coming back against you is that he was given 2 more opportunities to test, and he didn't take them. Why was the Court of Appeals wrong on that issue?
Appeals, so they're wrong because the statute only allows an employer to require a drug test once. And he provided a sample. They say it wasn't a sample. He said he urinated into a cup. She observed it. That's a genuine issue of material fact about whether or not he provided a sample. Nothing says they get to require more. Nothing in 730.5 says that the employer can request samples until they get the one that they want. Nothing in 730.5 says anything about temperature. He's just got to produce a sample that can be tested. There's a genuine issue of material fact about whether or not he did. That should be resolved by a jury, not by a judge. Now, was he aggrieved? I don't know how he proves the negative without the sample. So, that gets to, is he kind of injured in fact for standing purposes? Well, sure. I mean, he's probably entitled to a spoliation instruction. And so when the employer gets up and says, we complied with the procedures and he's not been hurt, he submitted Mountain Dew, what's he supposed to say? And our point was, if they get to do 3 samples, they get to do 5 or 50 or 100. And if the process is illegal, their position is so what? And there clearly has to be a limiting principle to that. And that's why the legislature says, you got to do it pursuant to this. And there's no provision for a second sample. Thank you.
Thank you, Your Honor. So if I may, first going to the question about the uniform disciplinary policy, there were some issues here as to whether Mr. Hampe would have been misled by the policies. I don't think there's any evidence in the record of any misleading. I think the record is abundantly clear that Mr. Hampe knew exactly what was going to happen when he made the decision to walk out of testing. He testified in his deposition that he knew that previously. He testified that he was told that repeatedly by the testing agent, Ms. McBride, who literally was following him out the door, telling him not to leave. He knew exactly what was going to happen. What was written in the policy was totally inconsequential to the issue. On the supervisory training issue, what we have here, I think, from the Court of Appeals is an effective nullifying of the aggrievement requirement. I don't think there's any way around that because I don't think there's any kind of a nexus between the training that's being challenged here and Mr. Hampe's walking out, directly contrary to what the supervisor was telling him to do.
To the argument that he thought that he challenged the first sample being an accurate sample, but it was dumped, and so he can't prove a negative. And he should never have been subject to a second testing.
So I think that issue largely, and whenever we're talking about she dumped it or who did what, it wasn't actually Charles Gabus Motors that was doing that. It was the third-party testing company that Charles Gabus Motors is required to hire. And that party was at the district court, was at the Court of Appeals. They're not here today because all the claims against them have been dismissed on this precise issue. And that's because they're the experts in the area. They had an expert witness who offered a report that was submitted to the district court, and the district court accepted it, saying, look, no, this is the way to do it.
Seem to run counter to what the statute says. I mean, the statute doesn't provide for dumping of samples.
Well, right, and I think we talk about the practical realities versus the statute itself and how do we apply this in practice. Well, if the statute says you collect it, the difference was made by the testing agent here to say there's a difference between what is a sample and what is a specimen. And I think that's what the expert report is focused upon, to say this is actually a sample.
That it looked like Mountain Dew?
Also tested outside of the range of acceptable samples. So I think they're the range.
Range.
think it can go up to 100, and that's undisputed. The testing agent said it was 104 degrees, and Mr. Hampe admitted seeing the result at the time and saying he saw 101, which would still be outside the acceptable testing range. So the expert says you couldn't test this even if you did retain it. So again, it's one of those, it's inconsequential.
Could you address Mr. Dickey's point of view that textually, if there's a failure to comply with either 8 or 9, then the entire testing process was illegal, and so anyone who was fired because of the testing process is aggrieved?
I'm not sure what language we're talking about in 8A, because 8A just talks about these are the pools of employees that could be subjected to testing. So I don't know where that comes from there. But for 9H, I believe is what it was, there's that prefactory language that says in order to do testing, you got to train your supervisors. I don't see anything in that statute that says that the legislature intended then to nullify subsections 15's requirement for aggrievement. I do often go back to that mantra that we have for statutory interpretation, specific would trump the generalized, and we have a statute that I think is specific to civil actions and requests for civil remedies, which is what this is. It says if you're going to bring those, you got to be aggrieved, whereas we have now 9H that's generally saying if you want to do testing, train your supervisor, which is generally a good idea, of course, but I don't think that would trump the aggrievement component. I think in this one,
9H, you have to show a nexus. You have to show that the lack of training led, that the supervisor made a mistake that mattered.
I think there's absolutely none here, and I think that's abundantly clear. This supervisor was trained. The record shows certificates that were identified going back to 2016, whether it's 1 hour, 2 hours annually, and she testified to even more. And the Court of Appeals looked at those certificate covers and said, hey, we can tell that one of the 3 areas of training was given here. We're not so sure about the other ones. Well, Ms. McBride testified, and that's in record, that says that her training covered recognizing someone under the influence, documentation, meetings, and things like that.
Aggrievement be met, I think what Mr. Dickey would say is, with respect to the composition of the pool and the training requirement, that employees who suffered no disciplinary action aren't aggrieved. So they can't bring a lawsuit for nominal damages because the testing was illegal. But somebody who ends up being fired because of a test that never should have been given is aggrieved. And that's how we make that distinction.
Training component. The trainings that we're talking about don't go to any of those issues. The trainings that we're talking about here only come into play when we have somebody with a positive test result or some indication of substance abuse, which Mr. Hampe affirmatively denies. It's not here. So the training doesn't go into, here's how to compose your employee pools. The training doesn't go into randomized testing or any of that other stuff. It's just recognizing employees that have substance abuse problems, documenting those problems, and then referring the employee for assistance. They don't go into how we structure the testing to begin with. So that's why I don't think there's any nexus. I see that my time has expired. Thank you.
Is hereby submitted, and we'll have just a few minutes for transition for the next case, Kester versus Irely Ball Community Mental Health Services.